Communicating with a client is perhaps the most important point of focus that any lawyer can pay attention to. In fact, I think that from my experience as a divorce lawyer, one can say that failure to communicate is the #1 complaint between husband and wife in a dissolution proceeding. So too with attorney-client relationships. It is the #1 complaint of clients coming before state bar disciplinary boards. My attorney didn't respond to me, didn't return my phone call, didn't respond to my note or my letter, what have you. Client communications is the #1 problem for lawyers. It has nothing to do with competency. It has nothing to do with quality of legal service. It has all to do with the communication process and the time you spend at it with your client. Now, where is it and how is it that clients communicate with us? Well, the first effort, the first time a client will communicate with us, most likely is when they call our office to make an appointment. The first person that they talk to is who? It's the receptionist. And so it seems to me that that position is the single most important position, aside from the practice of law, that exists in your law firm, in your office. When I was chief operating officer of a mid-sized law firm, we had a young woman who was just outstanding. And my colleagues wanted me to elevate her, to promote her. Well, in those days, the great promotion in their mind was to data processing. In my mind, that was just a drudge position. It was not allowing her or going to allow her any creativity. And I fought and I maintained her in the position where she was so effective, that is, in dealing with our clients. The first call that comes in, she was the person who answered the phone. And immediately they got a good reaction. They felt good about dealing with our firm. A second time that you communicate with your client is in your meeting, your first meeting, when you find out the facts, when you see if your client has a case that you're interested in and can handle and can help the client with. And also it's at that time that you're going to have a discussion about the fee. Make sure you have a complete and full discussion about the fee and what the expectations are, not only of you as the lawyer, but also of the client and the payment of the fee as and when the bills get sent to them. The third time that you will have a discussion with your client may be during surveys. You may send out a survey. One of my clients taught me a very important lesson. That lesson was, with every first billing statement that goes out of his firm, he sends a survey. The survey is only 4 or 5 or 6 questions, but it asks the client how the client was treated, what the client liked about the way they were treated when they came into the office, what they didn't like, and so forth. It was at that time that the lawyer was able to address any concerns that the client had. So that's the first survey, the first opportunity to do a written survey, if you will. Beyond that, during your representation of the client, ask the client, how are we doing? Are you receiving the service that you expected? Are you receiving the service that you wanted? Is there anything we can do to help you make this process easier? Now, obviously, we can't guarantee any results, but in terms of the service that we provide you, we can modify it, enhance it, or change it in a way that will serve your needs and wishes better. So those are times, it seems to me, that it is important for you to communicate with your client and do so with the opportunity for the client to respond. Bottom line here is that the open lines of communication between you and your client are essential for an effective and quality attorney-client relationship. Your client will walk away feeling well served and will then be in a position to want and to look for ways to provide referrals to their colleagues, because they want their people, their friends, their associates, their colleagues to be represented by somebody of compassion, such as yourself. Thanks for joining us.